Hi, it's Mike DelSignore, and behind me is the north end section of Boston, one of my favorite sections of Boston. But in today's video, I want to talk about what happens if you charge with a third offense OUI. If you charge with a third offense OUI, the first thing I want to tell anyone is that the first court date they may try to hold you without bail is a danger to the community. So make sure you have a lawyer for that court date. Typically on a third offense, I can avoid someone being held. Often you'll have to do two things. One, you'll have to get a SCRAM device, be alcohol-free, and be tested. Often there'll be a nominal bail, maybe $500 to $1,000. Depending on the court, sometimes bail's not an issue. If your offenses are a long time ago and you have a history of showing up for court, you might just be released, and you probably would be released just on the SCRAM device. Some courts we can avoid that, but generally you're looking at getting tested and being alcohol-free during the pendency of the case. The other thing I want to tell you is that when you charge with a third offense, you should get treatment, get help, because if you want to try to get this charge reduced to a second offense, we're going to have to send a letter, they call it a reduction letter, to the head DA in the court, and they're going to want to know what kind of treatment you've been doing, what's happened, what's going on in your life, and essentially a letter of mitigation. So I recommend that. If we win the case, great. You don't need it, but you'll likely need it for the registry, for other purposes. So treatment's always key and always a help. It'll never hurt you. Some people think that if you get treatment, they're going to assume that you got a problem or that you're drunk or you're admitting to the charge. Not at all. Always get treatment. And the final thing I want to tell you is that these are very winnable cases. They're crimes of opinion. The jury doesn't know it's your third offense. So while it is your third offense, the person deciding the case will keep that aside and won't factor that in how the case is resolved. So keep those things in mind when you are charged with a third offense OUI, because they're all very important. That these are winnable cases. There's a way to reduce the charge. There's a lot of legal work to be done in these cases, but I've done it for clients all the time, and I'll be glad to help you with your case. Also, if you refuse a breath test, it's a 5-year suspension for the refusal. You want to appeal that to the Registry of Motor Vehicles in Boston within 15 days. I've gotten these overturned for people on their third offense. I had a gentleman in Fall River, 5-year suspension, overturned with the RMV. He ended up winning his case, which also was terrific. We had a motion to suppress. The judge found there wasn't enough evidence to stop him. So in all these cases, there's a lot of legal defenses. The police have to prove that there's probable cause to stop you, reasonable grounds to order you out of the car, and then once you're arrested, they're going to prove this charge beyond a reasonable doubt, means the highest degree of certainty. It's a high standard of proof. I'll be able to rely on your medical records, witness statements, and other indicators to show that you weren't under the influence of alcohol. These field sobriety tests, I've studied these. I've taken the training of the officers. They're not accurate, reliable. They're not a reliable indicator whether someone has had too much to drink. And I'll show you how, when you talk to me, I'll show you how I can attack those cases in court. So if you have any questions, feel free to contact me. My name is Mike DelSignore, 781-686-5924. It's never too early, too late to call. I'm here to help.